Assalamu alaikum friends, you are watching Tax Dosti videos and we are discussing a very important case, a judgment by Sindh High Court on October 22nd, 2022. Today is 29th of January 2023 and it relates to Section 7E which was recently introduced, which is tax on deemed income. That is, if you hold assets in Pakistan, you have to pay tax on them. So it was challenged in the Sindh High Court on different grounds, and one was that it is discriminatory. Discrimination means that treating people differently of the same class. For example, here the class of persons that are being taxed are all those persons who hold immovable property as of 30th June 2022, and that property is above 25 million after the exclusions that are given in the Section 7E. So these people are being people who hold property more than 25 million of value are being treated differently. Some are being taxed under Section 7E and some are not being taxed. This is the claim of petitioners, 208 petitioners in this case, regarding Section 7E. So the judge in paragraph 10, and you're watching part 10 of this video, has given his logic whether he thinks this section is discriminatory or not, in line with the Constitution. As to the argument regarding the meting out discrimination to the petitioner as against the exceptions provided in Section 7E2, he is talking about a list of capital assets that has been included in subsection 2 of Section 7. These are different type of capital assets, mainly immovable property, that has been excluded from the tax of Section 7E. That is 1% of the fair value of your asset owned by you in Pakistan by a resident person. It can be safely held that this argument is not only misconceived but even has no force or legs to stand. This is the conclusion of the judge, that this section is not discriminatory. Time and again it has been held by the Honorable Supreme Court as well as various high courts of the country that legislation has the competence to levy tax on different classes of persons. जी सर, जी मैं सर वीडियो बना रहा हूँ. ठीक है, ठीक है, ठीक है, डन डन हो गया सर. अच्छा, so excuse for the call on different classes of persons, and merely for the fact that someone is exempted from the levy of such tax, it cannot always be pleaded that it is discriminatory in nature and is liable to be struck down in terms of Article 25. What is Article 25? Equality of citizens. All citizens are equal before the law and no discrimination on basis of sex, etc. can be made. So the judge is saying that in this case, the people who are being given exclusion, whose assets are not subject to 1% of tax under Section 7E, are not discriminatory because the legislature has competence to levy tax on different classes of person, and merely for the fact that someone is exempt from the levy of such tax, it cannot always be pleaded that it is discrimination and is liable to be struck down in terms of Article 25 of the Constitution, which means that if it is discriminatory, the court has the power under Article 25 of the Constitution, so equality of citizen, to strike down that law or that part of the law. It has been clearly established from bare pursuit of the impugned legislation that the levy has discriminated a same class of persons in order that the law be struck down on touchstone of Article 25 of the Constitution, meaning that how the Supreme Court and all the high courts have interpreted Article 25. So the standard which has been set it must be demonstrated that the said law is not based on intelligent criteria, meaning the people who have been exempted have been randomly exempted. There is no intelligence in exempting them from tax, does not have a nexus with the purpose of law. And here, definitely, this case has been cited 2018 PTD 336 regarding this standard of discrimination. Per standard law, the legislature is competent to classify persons or properties into different categories subject to different rate of tax. So, within a class of persons, that is, people holding immovable assets having fair market value according to FBR more than 25 million, all these persons become a class of person, and within this class there can be subcategories with different tax rates. So some have been charged like army personnel, federal and provincial government persons have been charged at the rate of 0% or have been exempted from this tax. Further, there the test of vice meaning the wrongness of discrimination in a taxing law are less rigorous, and if there is equality and uniformity within each group founded on intelligent differentia having a rational nexus with the object sought to be achieved by the law, the constitutional mandate that the law should not be discriminatory is fulfilled. Meaning that if within the class of persons the different groups or categories have been separated on some intelligent uh, criteria, then we can say that it is not discrimination. Now, I leave it to you to see whether all these classes of persons who have been excluded have has the legislator made intelligent decision or just random decisions or practical ones. When the impute provision of section 7E is looked into, keeping in mind the work dictum laid down by the Honorable Supreme Court, it clearly reflects the classes of persons who have been exempted from such levy are within the competence of the legislature as being classified separately, whereas it is not the case of petitioner that they fall within the same class of persons who have been exempted from the levy of tax in question. So, the federal legislature has made an intelligent decision and exempted the government officials and people working for the government, that is armed forces, and also they have laid down some conditions that a serviceman would be wounded or shaheed, or his dependent or an ex-army person, service person would have those conditions, then his property. In normal, if a person retires and an army person gets property, he is subject to this tax. So government has made a distinction, keeping in mind similar exemptions given in second schedule of income tax law. Much stress was laid down on subsection D4 of section as to why certain exemption a category of person specified therein, and to this it may be observed that the very exemption is also further clarified and is not generic in nature. Just as I said that conditions have been classified, not a blanket exemption has been given to every person. It only extends to persons specified in subsection D4 of section to the original allottees of the capital assets, and that also being duly certified by the allotment authority. It may be observed that such category of person is allotted various properties which fall within their terms and conditions of service from time to time, either as an incentive or on their promotion, whereas the exception provided is only to the extent of such original allotment and not thereafter. So, people who are given immovable property as part of their salary package, and especially people in federal, provincial government, armed forces, and services, have been given exemption from this tax, and it is only up to their original allotment. If they buy additional properties, they will be subject to this tax. So, in a way, there is clarity that people, if they do it for business reason, for earning income, they will be taxed. But since they have already paid tax on their salary. If they get this land in return, it may not be that problematic or discriminatory. Though it is settled law that the guarantee of equal protection of law also extend to taxing statutes, however, if the taxation, generally speaking, imposes a similar burden on everyone with reference to particular kind and extent of property on the same basis of taxation, the law shall not be open to attack on the ground of inequality, even though the result of taxation may be that the total burden on different persons may be unequal. And we can clearly see that if you are in a private sector, maybe the burden of tax may be on greater on you, but still the law has tried to be as clear as possible, and no inequality exists in the eyes of this judge and in this court, Sindh, the Honorable Sindh High Court. That's why he has said in the start of this paragraph that this section is not discriminatory. Hence, if the legislation has classified persons or properties into different categories which are subject to different rates of taxation with reference to income of property, such a classification would not be open to attack of inequality. This is not inequality on the ground that the total burden resulting from such a classification is unequal. If you take a similar example, any person earning 5 million in Pakistan has to pay about 6 to 7 lakh rupees. But if his income is exempt, for example, in case of IT freelancers, or he is a seafarer, or if that amount is a pension, his first pension, then he will not be required to pay tax. So anyone earning 5 million as business income will pay taxes at different rate. Anyone paying for as 5 million as salary will be paying different rates, and anyone exempted will not be paying it. So this does not amount to inequality in the eyes of law and this court. In deciding whether the taxation law is discriminatory or not, it is necessary to bear in mind that the state has a wide discretion in selecting the person or object it will tax, and that a statute is not open to attack on the ground that it taxes some persons or objects and not others. So if some are left out because of some intelligent criteria, it cannot be said that it is discriminatory, since it has some logic. In the celebrated case of I.A. Shinwari, while deliberating on question of equal protection in law, the Honorable Supreme Court has been pleased to honor that the equal protection of law does not envisage that every citizen is to be treated alike in all circumstances. That all citizens can't be treated alike in all the circumstances means that there can be differences created by law. So Section 7E is creating a difference, but it contemplates that persons similarly situated or similarly placed are to be taxed alike, that no standard of universal application to test reasonable of classification can be laid down as what may be reasonably classified in a particular set of circumstances. So if a person buys a property and he is serving or retired army person, and a private sector person buys property, both will be, and if they hold it as at on June 30th, 2020, both are subject to Section 7E. May be unreasonable in other set of circumstances. And finally, that in order to make a classification reasonable, it should be, and this is the criteria, on an intelligent differentia which distinguish persons or things that are grouped together from those who have been left out, and that the differentia must have rational nexus to the object sought to be achieved by such classification. At paragraph 26 of the said judgment, the Honorable Supreme Court has deduced the principle of law that equal protection of law does not envision that every citizen is to be treated alike in all circumstances, but it contemplates that persons similarly situated or similarly placed are to be treated alike. So all persons getting being first allottee of armed forces will be treated alike. It has been further held reasonable classification permissible provided that it is based on an intelligible differentia which distinguish persons or things that are grouped together from those who have been left out, and that the differential must have rational nexus to the object sought to be achieved by such classification. It may further be pointed out that different laws can be validly enacted for different sexes, persons in different age groups, persons having different financial standings, and that no standard of universal application to test reasonableness of a classification can be laid down, as what may be reasonable classification in a particular set of circumstances may be unreasonable in the other set of circumstances. So the judge is relying on this Honorable Supreme Court judgment, is laying out that this section is not discriminatory. Going further, it has been observed that the question as to whether a particular classification is valid or not cannot be decided on the basis of advantage and disadvantage to individual assessees, which are accidental and inevitable and are inherent in taxing statute, as it has to draw a line somewhere, and some cases necessary may fall on the other side of line. So there may be hardship for some people that may be included in a certain group according to tax law, just like in section 7E here. Therefore, in essence, no discrimination can be pleaded on this ground alone. Moreover, in terms of section 7E2G, a reasonable exemption has also been provided to all taxpayers in respect of properties owned by them having a value of up to 25 million, meaning that the court agrees that even if people have properties that fall under section 7E, that is after excluding one capital asset, one agriculture, one business asset, etc., then again their fair market value, if added up, will only be taxed once it goes beyond 25 million. So a exemption of 25 million saves many people who hold the property for their own saving or for future building of their homes. But those who hold, the main purpose is to discourage people from holding properties in their name, because if they have many files, plots, houses in their name, definitely their fair market value will be above 25 million, and then they should pay for those assets since they have invested in it. And so far in this video, part 10, we have discussed that the judge is convinced that the petitioners are estoppelled by pleading discrimination when they themselves have been provided a benefit thereof. Resultantly, the argument that the impugned levy is discriminatory is per se devoid of any merits, hence not tenable, meaning the judge is not convinced by any of the advocates of the petitioner, or by reading the law, or by previous cases of Supreme Court in tax cases and in general law principles, that this section 7E tax on deemed income is discriminatory. In the next video, part 11, that is paragraph 11, we will see if this tax is confiscatory nature of levy, meaning that it is too much of a burden on any one or a group of taxpayers. Now, all of this you have to consider that the advocates being present have made their arguments, and the judge is deciding after reading all these arguments. Thank you. See you in the next video.